Advocate Pitman.
Good afternoon, Chief Justice.
How are you?
I'm fine, thank you.
I'm good. You were here just exactly a year ago.
Exactly.
And we gave you a thorough going over. So I don't imagine that will be very long with you. We do have a full transcript of your previous interview to this for a position in the same division in front of us. You have a BA and an LLB from the University of KwaZulu-Natal.
Yes.
And you have been an advocate since 1994.
Yes.
Practicing at which bar?
In
KZN.
In KZN.
Mm-hmm. But before that, you were a prosecutor for about 3 years?
I was a prosecutor for 4 years, and 4 to 4.5 years, and a magistrate in the district
then
criminal
a magistrate
court
for how long?
4.5 years also.
All right. You have not taken silk. I recall that last time you were here, you said you may go towards that direction.
Yes.
Have you taken any steps towards that direction?
Yes, I did.
Oh.
I made inquiries about the procedure that's currently applied in the context of the LPC and the bar, and I was informed that the current scheme of legislation, there is a committee that requires to consist of 2 senior attorneys, and because there aren't any in terms of the relevant legislation, the committee, there needs to be some adjustment made before applications can actually be considered. And that's when I put my name forward again for this position.
All right. Have you had another acting stint as a judge since your last interview?
Yes, I've just come off a 4-week stint.
Oh, for how long?
A 4-week stint.
All right. And what kind of cases did you do?
It was in the Durban Civil Division. I did, for the first 2 weeks, the medical negligence trial, and for the second 2 weeks, the usual motion courts, opposed motions, judicial case management, etc.
All right. So, in addition to what you already know about you, what fresh, relevant information would you want to bring to our attention?
I don't think there's anything very special that's new with respect to Chief Justice. I would consider it an honor being a judge. I would consider it a great honor to be able to spend my last decade in law, serving the division which has been so good to me. I have practiced law in the division of KZN for 40 years in one form or another. Either as a prosecutor or a magistrate or an advocate or an acting judge. It's given me everything that I have in my life. It's become a part of me. I often say that I don't think that advocates can retire, because being an advocate becomes so much about your existence that if you retire, you're almost giving yourself up. But I just think that in the circumstances, I owe it to my division to at least make that 40 years worth of experience available, if it can be of any use. And I think becoming a judge is a calling rather than a professional step. And I feel that if the time is right, then I will be called.
Thank you. Judge President Poyotrat.
Thank you, Chief Justice. Good afternoon, Advocate Pitman.
Hello, JP.
Indeed, you acted in the past 4 weeks, and you were full of energy, I must say. You are going to be turning 65 in the next few days, and you know how the workload is in the division. Do you think you will be able to cope at your age?
Without a shadow of a doubt.
Yes. At least you have not given me or the DJP an indication that you might not be able to cope because of your age.
I love the work.
Yes. And in the reserve judgments, what is the longest time that you've taken to hand down a reserve judgment?
I see that from the responses by one of the associations that the longest time I took was 6 months in 2021 for a judgment. Other than that, they've all been within the 3 or 4 month period. The judgment in 2021 was a judgment that was a trial that I heard in a matter involving the Durban City Council, which was quite complicated, and my acting stint came to an end. It was in the Christmas period, etc., etc., and that was one of the reasons why the judgment was delayed a little bit. But it was complicated to the extent that in the last couple of years, it's wound its way finally through to the Constitutional Court. It's the double daily matter, where leave to appeal was finally disposed of, refused.
Yes.
So that's the longest.
And just on the acting stint that you've just had now, you were more than willing when I had to reshuffle the role in order for you to do at short notice with an opposed application.
Yes.
If you are recommended, will that not change?
No.
Because people tend to complain, particularly if you give a very short notice on a voluminous matter which is opposed. Will you not change? I do want that assurance.
Absolutely not, JP. I will not change. You will remember that, in fact, you bounced me with two unusual matters. The first was that medical negligence trial, which was due to go to another judge who couldn't do it. I was very happy to do it. In fact, I really enjoyed the matter. It involved experts from Scotland. And as for the opposed motions, can't wait to get into them in the future if you have me.
And then lastly, in the last interview, I'm sure you've had time to reflect and to also go through the transcript. Are there any lessons or anything that you took from that, and any self-correction, maybe if necessary? Is there anything that you've learned from that previous interview?
It's a difficult question. I think maybe I focused too much on the kind of human being I was rather than the job that I do. I was hoping that I could today focus on the job that I do and that I can do, and that the benefit I can be to our division.
Thank you. Thank you, Chief Justice.
Thank you, JP. Premier?
No, thank you, CJ. I have no question.
Commissioner Kotsal?
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
Advocate Pitman.
Good afternoon, Commissioner.
The JSC was deliberately structured after 1994 to safeguard against the kind of narrow and unfair practices of appointing judges in the past. And law bodies were, as I understand it, intended to contribute a professional and transformational perspective to the balance. Now, in this process, I've noted that the BLA have changed their position on your candidacy since last year. And I was wondering how you firstly understand the respective roles of both the law bodies and the politicians and other role players in the JSC, but also what you make of the shift in their position.
All right. I think that in a multicultural society like the one we have, it's essential that judges reflect the demographics of the society that they serve. And in order to do that and to give legitimacy to the judges, I think the constitution of the JSC as it is today, which has lawyers as well as other representatives of society, is an excellent way of achieving that end result. Laws like clothes are meant to fit the people who have to wear them. And you can't do that unless you have a multicultural approach to the appointment of judges. The second question second part of your question, I'm sorry, I can't remember it.
I'm sorry, I should have asked it two sections. It's what you make of the change in the BI's positions nearly a year later.
To be honest with you, I didn't realize they changed their position, but I'm very humbled. I must just tell you that I'm very humbled by what they say at the moment. I think they remark about how my appointment would equalize the demographics or help towards the equalization of the demographics of our division. That to me is a humbling submission, and as a white male, and I appreciate it a lot.
If I may, CJ? If I may just...
Okay.
So my understanding is that the change was as a result of a reflection on what I think you termed it nursery chambers. And have you done anything in the past year to change or to enhance
Sorry,
that
sorry to
nursery chamber?
So the nursery chambers I called it the nursery chambers, and it wasn't meant in any way to denigrate or the people who were in it. They were just too grateful for the opportunity to get chambers at a heavily subsidized and reduced rate. It initially was, because when I started at the bar in 1994, everybody was in a building in Smith Street. And the top of the building had what was called the nursery chambers, and they were very small little chambers that newly admitted advocates could rent at a cheap rate. And I thought it would be a good idea to have that kind of scenario for our group of advocates. The nursery chambers was originally one room, which was subdivided up into different sets of chambers effectively. It's actually morphed now into a situation where on the floor that I'm on and around me, most of the chambers are shared by, with permission of the bar, are shared by junior advocates who just need the help financially. So it's actually improved.
Thank you, CJ.
Speaking for myself, I thought the name is quite endearing.
Thank you. Thank you.
Minister?
Thank you very much, CJ. Good afternoon, Advocate
Good
Pitman.
afternoon. Good afternoon, Commissioner.
The first issue I just want, probably one question I would have around access to justice. And I'm particularly interested in this area when dealing with provinces such as KZN, which is a rural province, takes long in all the services that you provide for people to travel. And therefore, my issue is how can the judiciary play a role in ensuring that there's access to justice, especially for the most vulnerable people in our communities, where they might find, because of their legacy of apartheid, you have the infrastructure in various areas where it's not accessible to many people. How do you think that that could be corrected, and how can we ensure that those that are the most vulnerable, most needy, who do not have the resources, have access to justice?
Thank you. As an individual puisne judge, which I would be if I were to be selected, I'm not sure that there is very much that I can personally do. However, having said that, your question relates to the judiciary, so I'm going to answer it as if I'm talking about the judiciary as a whole rather than simply my position as a possible judge. It is true that our society is still scattered all over areas of South Africa that are inaccessible to even a motor vehicle. But it is also true that our judiciary has done a lot to render accessible facilities and services. I'm aware of the fact that there are circuit courts for the High Court who travel to various other areas in order to provide services to people who may not be able to get right the way into the big cities. As a public prosecutor, and as a magistrate, I was very aware of the fact that each district, the country is divided into districts, and each of the districts has its court system. And witnesses who had to come to court from outlying areas are given witness fees, their travel expenses are paid for. So that was a help. As far as criminal cases are concerned, where witnesses had to be brought as part of the state case, the investigating officer, the police force, would always ensure that they are brought to court. So I never got a sense that there were people out there who were desperately trying to get to a court and couldn't get there. But I'm sure that that is the situation on some occasions. Other than the fact that it might be a good idea for someone to sit down and have a look at whether there is a budget for or an opportunity to further extend circuit courts, create new circuit courts, or new district magistrates' courts, I'm not certain how one would be able to deal with it completely. But I do think that our justice system and our judiciary have made leaps and bounds in making access to justice on that basis of availability of being able to get to court as simple as possible.
Thank you, CJ.
Thank you, Minister. Prof?
Thank you, CJ. Good afternoon, Advocate Pitman.
Good afternoon, Commissioner.
I had an occasion to read one of your judgment, which I found very interesting, by the way. It is found in page 137 of the paginated bundle. I'm not really sure if you have the same. It is MBFM
Yes.
versus, it was an application in terms of Rule 28 of the Uniform Rules of
Yes.
Court. But obviously emanating from the matrimonial, the divorce proceedings, I guess, that way before the court. What is interesting to me, it is what is stated in paragraph 11 of that judgment. And it doesn't appear to be wrong, and I'm not suggesting that you are wrong. It's just that I just want to understand the methodology. Perhaps maybe you may be right. My understanding in this matter is that the applicant wanted to amend their summons. And obviously, they attached what you refer to as irrelevant documents in the application. I'm not necessarily concerned about those applications. I'm concerned about the substance of the amendment. In that paragraph 11, you sort of provide guidance on how an amendment in relation to universal partnership should be done, and you refer to the essential areas of that particular contract. What I want to ask is it permissible for the judge to provide a judicial advice in a judgment? In other words, to dictate how the party wants to amend their pleadings? Because my understanding, correct me if I'm wrong, is whether or not the grounds for amendment following the objection have actually been made. So I was just interested to understand the rationale behind giving when I'm reading this paragraph, it seems to be an advice, like, no, don't do it this way, do it that way. Is it something? And I'm not saying you are wrong. Perhaps I'm just curious about it.
Yes. That's an interesting question, I think. So, giving a judgment per se is always giving advice, because the judgment constitutes your reasons, includes your reasons for arriving at a conclusion, and for people reading it in the future, that will constitute some sort of advice. But that doesn't really answer your question. What your question is relating to here is whether, in this particular paragraph, I have sought to give legal advice unrelated to the judgment I was giving.
No. The question is, given the fact that the party, as I can see here, they are legally represented, and my understanding is their legal representation, legal representative advised them that we need to amend our papers in this way for us to get the relief that we ultimately are seeking. So they have done that already. You have reflected on the papers, and you have the view perhaps maybe that the amendment is not adequate. And then you are commenting on how it has to be. And you are going as far as providing the elements.
Yes.
And we are dealing with summons, because the summons, you will have your course of action, and the facts that support your course of action. And what I kind of see here is they actually amended to provide facts that support their course of action. So I was just interested as to what was your methodology in giving this advice.
Yes, so my thought process is this: to say to a party, look, you want to amend, you say this amendment is sufficient. This is actually what you require to demonstrate. You have or you haven't. In order for me to justify my reasons about when I say this is what you are required to plead, the factor probanda, I would refer to authority as I have here. So it's part of the reasoning process that I've set out as to why I came to the conclusion that I did.
Very much.
Thank you.
Thank you, CJ.
Any further questions, colleagues? All right, that brings us to the conclusion of this interview, Advocate Pitman.
Thank you very much, Chief
Thank
Justice.
you. You're excused.
Thank you very much, Commissioners.